Good afternoon and welcome to the latest installment of our Covenant Wealth Strategies Stone Barn Speaker Series. My name is Ward Keever. I'm joined by Michelle Fisher. Today is Thursday, May 20th, 2021, and we are honored to have with us the fabulous Ms. Carolina Heinle, estate planning attorney extraordinaire. I should tell you that Carolina and I know each other just a little bit, so I think you're in for a fun afternoon. Not a word that you would typically use to describe the topic of estate planning, but actually a fun afternoon talking about estate planning. And I would in fact also say that the one word that I use to describe Carolina most often, which by the way, Carolina is an attorney, so understand that. Carolina is an attorney, and Carolina is an estate planning attorney, and you know what she's going to talk about because it's estate planning. But the one word that I would use to describe my good friend, Ms. Carolina Heinle, is that she is fun, which is a word that you would just generally not associate with estate planning attorney. So we're thrilled to have Carolina with us here today. I can tell you a bit about Carolina's professional background. She is an attorney with over 10 years of experience, is licensed to practice in both Delaware and Pennsylvania, focuses almost exclusively in the areas of estate planning and estate administration and probate. Carolina advises clients on state and federal taxes, as well as life insurance and retirement plans, lifetime gifting, and asset protection planning. Carolina is a graduate of the Tower Hill School here locally and attended Haverford College, where she studied philosophy. She then went on to receive an MA in religion and ethics from Yale University Divinity School before graduating cum laude from Villanova University School of Law. So Carolina is married to her husband, Court, for 10 years. Together they have 3 young men and 1 little princess. And so that's the official introduction for Carolina Heinle. Now, I could tell you many things. I could tell you many, many things, but I won't because Carolina could also tell you many things, and we don't want to go there. So the one thing that I would simply point out to you, Carolina is a friend of our family. She is a friend of multiple generations of our family. And my in-laws, my wonderful wife, her parents, they actually have a picture of Carolina on their refrigerator. So you know how you put pictures of family and loved ones and everything else on the refrigerator? Well, I want you to understand that Carolina is so loved by our entire extended family that her picture is on my in-laws' refrigerator. And I should just mention that my picture is not on the refrigerator, but Carolina's picture is on the refrigerator. So we are thrilled to have Carolina with us. She's going to talk to us about estate planning and legacy planning. We will have time for Q&A, and so we would ask that if you have questions, you'll be able to send your questions in by email this afternoon, and you will be emailing Michelle at covenantwealthstrategies.com. And as those questions come in, we'll take a look at them. If there's something that seems especially pressing, I may interrupt Carolina, but for the most part, we would expect to hold your questions until the end. You can send your emails in anytime, but we'll likely hold the questions until the end. So, Michelle, did I miss anything? I missed a lot. There's a lot that I could have said, but Carolina, I'll save it for a little bit later in the presentation. Without further ado, Ms. Carolina Heinle, thank you.
Thank you, Ward and Michelle. I was worried about what you were going to say. So I will say I'm really, really happy to be here. Ward and I have done this multiple times at this point, done these joint presentations. So I'm always happy to do them. I have known Ward now, I think we're going on 5 years.
Seems like longer than that, doesn't it?
It's been a long time, yes. And I am very fond of his entire family and his in-laws and his parents. So it's a wonderful family to be a part of. So thank you for having me. I will say at the outset, I'm not great at multitasking, so I'm in charge of the getting through the slides and talking. So Michelle, if I'm delaying in the presentation, just like flag me and I'll hit the page down button. Okay, all right. So I can't see anybody, so I'm just going to focus on Ward and Michelle while I do this. All right, so I'm here to talk to you about estate planning, which has become really important, particularly in the last year. We've gotten a lot of inquiries from people who have just gotten nervous because of the pandemic and want to get their affairs in order. So this is a really particularly relevant topic for right now. I'm assuming that most people know what an estate plan is. It's basically a plan that we're putting together to address what happens to you and your assets, and not only in the event of death, but also in the event of incapacity. And a lot of people forget that it is just as important to plan for incapacity as it is for death. So I get asked the question all the time, who needs an estate plan? I think everybody does. What kind of estate plan you need is going to differ, but at a minimum, if you are 18 or have kids or grandkids who are 18, they should have an estate plan. Their estate plan is going to look very different, but at a minimum, they should have powers of attorney and healthcare powers of attorney, and we'll get to that later. If you have minor children, you should have an estate plan because that's your opportunity to address who's going to take care of them in the event, God forbid, both of the parents have passed away. So estate planning is not just for people who have, significant assets. There's something for everyone. Okay. So let me just go through this. All right, I'm just going to skip to. All right, so planning for incapacity. So when I do these presentations, oops, I went too far. When I do these presentations, I like to talk about incapacity first and then moving to planning for death. So as we all know, accidents happen and life can change really, really quickly. And if you don't have documents in order that direct who is able to make decisions for you, then ultimately the court has to get involved. A court-appointed guardian might have to get involved, and what that person will decide for you might not be what you would have decided for yourself. So the first document to talk about are they're called healthcare directives. Sometimes people hear them as healthcare powers of attorney. They're sort of interchangeable terms, or a living will. I'm going to speak in general terms. Like Ward said, I'm licensed to practice in Delaware and Pennsylvania. The laws are slightly different between the two states, but I'm just going to speak in general terms because for the most part, they're the same. So your living will is the document that is going to give you the opportunity to address your end-of-life instructions. Which some people, it's very important for some people to document this. If you're in an end-of-life state, permanently unconscious or terminally ill, do you want to instruct what kind of care you receive or you don't receive? Or do you want somebody else to make the decision for you? Equally important is a healthcare power of attorney, which is your opportunity to appoint someone to make non-end-of-life medical decisions for you. So if for whatever reason you're not able to make a decision on your own care, then you need to appoint somebody to do it for you. A DNR, a do not resuscitate order, this is a really important order. This is a physician's order. I get this question a lot, which is why I wanted to include it. A lawyer cannot issue a DNR order, but if it's important to you that you are not resuscitated in certain circumstances, then that is something that you speak with your physician about, and he will write the order for you. Then we move to financial incapacity. What happens if you're not able to manage your financial assets? And this is where this is where I see a lot of litigation in my practice, because a lot of people assume mistakenly that if you don't have a power of attorney, that your spouse automatically gets to make financial decisions for you. And that is actually not the case. So if you want your spouse to be able to make financial decisions for you, you have to proactively appoint that person in a financial power of attorney. It is the case that your spouse has, by law, your spouse has the first bite of the apple. So your spouse is first in line to be appointed that guardian, but that appointment only happens with court intervention. So the easiest thing to do is just plan for your incapacity, appoint your spouse, and then appoint your children or whomever is next in line. And that's how we avoid the situation. I'm in litigation right now, or my office is in litigation right now with a power of attorney issue where our client did not have a power of attorney. 3 people presented themselves as potential powers of attorney, and 1 person was appointed. It was the wrong choice, and that person basically took like $300,000 of assets from our client. So we're in some litigation right now. So the power of attorney is an important tool. Another option that is available is joint ownership. Most people, like most married people, have assets that are jointly held. Real estate is the primary example, but also you can have jointly held bank accounts. As long as there is joint ownership, then we have 2 people who are able to access the asset, which is a good way to make sure that someone can always act. Of course, then the problem is when you have 2 owners and 1 owner passes away, then we have to make sure that the surviving owner has somebody lined up, and that's when the power of attorney comes into play. We're going to get to the trust later. So, all right. And one thing I wanted to mention, because I had a client ask me about this, and I made a note here. There's a movie that came out not too long ago called I Care a Lot. I haven't seen it, but I've heard of it, and I know what it's about. And I had a client ask me about this the other day. So I Care a Lot is a movie about a court-appointed guardian who makes a living out of defrauding elderly people. It is an exaggeration of something that actually happens quite a bit. So the basic premise is this woman convinces the court that her victims need guardianship because they're not able to care for themselves. And the court grants her guardianship over these people, and once she's the guardian, she has unfettered access to all of their assets, and she moves them into facilities and then drains their bank accounts. And it actually happens. Like I said, it's an exaggerated example, but it does happen. The best way to prevent this kind of abuse from happening is to have these financial powers of attorney and these medical powers of attorney, because you are proactively saying to the court, if for some reason someone needs to take care of me because I can't take care of myself, I want it to be this person or this person or this person. And that limits the ability for a random third party to come in and basically take over for you. So I just wanted to mention that because the client asked me about that the other day. Okay, so the planning for incapacity piece is pretty straightforward. We handle it mostly with powers of attorney and healthcare powers of attorney and living wills. Then the question is, well, what happens when you pass away? And that's where we get into this idea of estate administration or trust administration, which is basically the distribution of your assets. I'm sure that most of you on here are familiar with the process of probate. Maybe you've actually been through the process of probate because you've been named somebody's executor in a will. But for those of you who are not familiar with it, like a 30-second overview, probate is the process where the executor of the will files the will with the Register of Wills of whatever county where the person passed away. And there's this process, it's about a year long, and at the end of this process, the assets are distributed to the beneficiaries of the estate. The problem with probate is it takes a long time. In Delaware, in both Delaware and Pennsylvania, it takes about a year from start to finish. And it is a completely public process. So every filing that is made with the court becomes available to the public. And the other problem with it, and this is specific to Delaware, is there's a fee associated with the probate process. And the fee is 2% of the net value of the assets passing through probate. So in Delaware, we are incentivized to try to avoid the probate process. But if you pass away in Delaware and you have a will, you can count on your executor having to do about a year's worth of work before your beneficiaries are going to receive their share of the estate. Okay, so as I indicated, oops, I went too far. The cons are, it takes a long time. It's all a matter of public record. It can be expensive. And there are some pros. Really, the only pro that I can think of is it's a court supervised process. So it's very transparent. So it's harder for executors to abscond with the money because they have to be very transparent about what they're doing. So the question that I always get is, can you avoid this probate process? And the answer is yes. And then the next question is, should I avoid this probate process? And the answer is yes. So as an attorney, an estate planning attorney in Delaware, I do a lot of trust planning for my Delaware clients in particular. But most of my clients, even who are not Delaware, are keen to avoid the probate process in general. So I do a lot of trust planning for them as well. There are a couple of ways to avoid probate, which I have here on the screen. The easiest way, or the two easiest ways, are joint ownership. We mentioned before where we have two owners, we have two people who are basically controlling the asset. So husband and wife own real estate together. If husband passes away first, the wife automatically becomes the owner of the real estate. That happens completely outside of the probate process. There is no real paperwork that has to be filed, and the wife becomes the sole owner of the property. So we've avoided probate from husband and wife to wife. The question then becomes, well, what happens when the wife passes away? And that's where we have to do some trust planning, which I'm going to get to, I think, in a couple of slides. But joint ownership avoids probate as long as there are two spouses alive or two owners alive. Another really useful way to avoid probate that I am a very, very big fan of because it's easy is beneficiary designations. So with few exceptions, if you have the option to utilize a beneficiary designation, you should. And the assets that we typically see are life insurance policies and retirement plans. If you can name beneficiaries on those assets, you should. What happens when you pass away? The plan administrator usually only requires a death certificate to establish that the death has happened, and then the plan administrator will pay the assets over directly to the beneficiary. That happens completely outside of this probate process. It happens relatively quickly, I would say within a matter of weeks, and the money goes directly to the beneficiaries. So it's a great way to get money to people quickly.
Hey, Carolina,
yeah.
Question for you.
Yeah.
So question for you is from time to time, people will ask us or we will see that on, say, for example, a retirement account or a life insurance policy, they have actually named their estate as the beneficiary. Is that typically advisable?
It is not advisable at all. And the reason it is not advisable is if any asset passes through your estate, you are essentially requiring that that asset go through this probate process. And the probate process, as we just talked about a few slides ago, takes a long time. And if it is a Delaware estate, will be assessed this 2% fee. So if you have a $500,000 life insurance policy pass through your estate, not only are you delaying the beneficiary's receipt of that money, you are also reducing the beneficiary's share of that money because the state of Delaware is going to take 2% off the top. In addition to that, when an asset passes through the estate, your creditors have the first right to make a claim against the estate. So in every state, there is a law that requires or that allows creditors to have first bite of the apple. In Delaware, it is an eight-month period of time from date of death. In Pennsylvania, it's a year. So if you pass your $500,000 life insurance policy through your estate and you owed $300,000 you had $300,000 of credit card debt when you passed away, the credit card company is going to take $300,000 of that $500,000. Whereas if you pass the money directly by way of beneficiary designation, your creditors can't access that money because it never passed through the estate. And the final point I want to make, Ward, is when it comes to retirement accounts, passing them through the estate collapses all of the income tax benefits that are associated with retirement accounts. So retirement money should never go through the estate. It's going to be heavily taxed, and we lose a lot of the benefits that the beneficiaries could have inherited.
Thank you, Carolina. Yes, ma'am. Thank you.
You're welcome. And I will say one final point. If you out there listening to this, if you're hopefully still listening, if you take nothing away from this meeting, I urge you, the one thing you should do is check all of your beneficiary assets, so life insurance and retirement in particular. Make sure you have a primary beneficiary listed and a secondary beneficiary. A lot of my clients swear that they do, and it turns out that they don't. I love working with Ward because he goes through these beneficiary audits, which I think is really great, and he really makes it a point to confirm we have primary and secondary. If there is no beneficiary listed on the asset, or there is a beneficiary but that person has died, the default beneficiary is the estate, and we have all of these problems. So if you take one thing away, have it be that.
And while you're on that topic, can we just point out another scenario regarding beneficiary arrangements? So let's just say that a couple of years ago, maybe a client did a beneficiary audit and verified that they have primary, that they have secondary or contingent beneficiaries listed. In the interim, maybe they got divorced or some such thing, and now they're remarried. And they came to you right away, of course, and updated all of their estate planning documents. Having updated their estate planning documents, now that they're remarried, are they finished?
They are not finished. You have to change all of your beneficiary designated forms. They are separate entities, and the one has nothing to do with the other. So you can write in your will, I leave my life insurance policy to my next door neighbor. And if your life insurance policy lists your son as your beneficiary, the money's going to your son. So they're separate entities, and they have to be handled completely separately. So if you have
even though this person got divorced and remarried, and they named their new spouse in their estate planning documents, if their life insurance policy still names their former spouse as the beneficiary, then upon their demise, the former spouse, in fact, inherits the life insurance. Let me just say that that's not a good experience.
It's not, you know? and I go through it with my clients. There are certain assets, like a 401k, in certain states, a divorce will nullify that beneficiary sometimes. But of course, there's this presumption if you update your will to exclude your old spouse and include your new spouse, but then you leave your old spouse as the beneficiary of your life insurance policy, there's of course this presumption, well, that was intentional. You made the change in your will, you didn't make the change for the policy, so that must have been what you wanted.
And people might say, well, that's ludicrous. Obviously, I would not want my former spouse to be the beneficiary of my life insurance policy. Everybody should know that. But in fact, there are oftentimes scenarios where an ex-spouse or even the courts will require a life insurance policy be payable to the former spouse, perhaps to guarantee child support payments or other reasons why life insurance, in fact, on purpose, may still be payable to the former spouse. So it cannot be assumed that, oh, everybody should know my new spouse is supposed to be the beneficiary. And I guess the key takeaway I would say there, Carolina, is that the beneficiary designation supersedes the estate planning documents.
Always.
And a lot of times people don't understand that.
Always. It always supersedes. Always. The other thing, now that we're on the topic of that bears mentioning, because I see this a lot in my practice, if your intent is to leave everything in equal shares, 50-50, to my kids, that's what your will says, but you have a bank account at M&T, for example, and on the M&T bank account, you have a transfer on death or pay on death designation to one of your children. That account, when you pass away, is going to pass to that sole child. And people have to understand this. A transfer on death or a pay on death designation is essentially a beneficiary designation. You are instructing, when I die, transfer this account directly to this beneficiary. So if I left a bank account to one of my sons, but in my will, I said I want all of my assets to go equally to my four kids. I won't tell you which one I forgot. So if I left all of my money to my four kids in my will, but this one bank account is passing directly to my son, that designation controls. So you have to, a lot of estate planning is just making sure that you are aware of all of your assets and you're aware of where you are directing that they go at the end of your life, because it's not uncommon for you to think all of my assets are going to end up with my four kids, but in fact, that's not going to happen because you have these transfer on death designations. The other time that I see this is when I have like an older client who, she'll say to me, well, I added my son onto my account because I wanted him to be able to access it. So I added his name, but when I pass away, I want that account to go equally to my three kids. And I have to say, Mrs. Smith, if your son is an owner of your account, when you pass away, that account is his. He is under no legal obligation to split it with his three brothers. And then Mrs. Smith says, oh, okay, but I'm sure he'll do the right thing. And I say, Mrs. Smith, I'm sure he will do the right thing, but if he takes his money and gives it to his siblings, he's now making a gift. and he now has to think about gift tax implications. So I'm getting really into the weeds here because, Ward, your question prompted all of these answers. But I think the takeaway is it's just really important. A lot of estate planning is just asset coordination. You have to understand what your assets are and where they're going to go at the time of your death. Okay.
Well, Carolina, I appreciate you getting into these weeds only because you and I see these things so often. Mm-hmm. It is as common as dandelions in the backyard in April, right? To have a client say, oh, I added one of my kids onto all of my bank accounts so that they can help me with paying my bills, or if something happens to me, they have access to the money or something like that. And they don't understand that they've just changed the title on the account, and that the title, similar to beneficiaries and account titling supersede your documents. So we went to all the trouble and the expense to connect with a fabulous estate planning attorney like Carolina, and we got the documents, and we have the will and the power of attorney and the healthcare directive, and we even set up a trust to avoid probate, thinking we're all set now. But then as we tell our clients, good job, you're halfway finished.
Right.
Now we need to come back, now that you have the documents, now we need to come back and coordinate beneficiaries and asset titling. And the simple concept of being like, oh, I just added my son, to my account so that he can help me pay my bills and have access to the money if something happens to me. Unless you want that son to have all the money in the account when you pass away, you might not have realized it, but you just completely defeated your estate plan as it pertains to those accounts.
Yep, that is right, and I see it all the time. All right, I'm going to skip over lifetime gifting, and I'll get back to that. I just want to make sure we have enough time for trusts. Okay, so prior to our detour, we were talking about probate, and I do a lot of probate in my practice, so I'm very familiar with it. And sometimes it's fine and it's not really a big deal, but most of the time probate is a nuisance, and I am always frustrated when I see that probate could have easily been avoided had a little bit of work been done up front. So I get a lot of clients who come to me, and other attorneys have done their documents, and I see we have this probate problem, and I just get very frustrated because it's easily avoidable. So everybody, I'm sure, has heard of trusts. They are an extremely versatile estate planning tool. There are all kinds of trusts. For purposes of this discussion, I'm going to talk about one specific kind of trust that is called a revocable living trust. It's revocable because you have the ability to completely control it, change it, revoke it, amend it at any time in your life, as long as you're competent to do so. And it's a living trust because you set it up during your lifetime. So we're going to focus just on this revocable living trust. A trust, for those who don't know, I get this question all the time, Carolina, but what is a trust? We've heard about this, but what is it? So a trust is essentially a contract, and the contract is between three people, the grantor, the trustee, and the beneficiary. So if Ward were to come to me and set up a trust, the Ward would be the person who sets it up, the grantor. He would be the person who would manage the assets, the trustee, and he's also the person who benefits from the assets, the beneficiary. So during Ward's lifetime, he serves in all three capacities. So there's very little change that Ward sees in how he's interacting with and managing these assets on a day-to-day basis. The sole difference is Ward Keever is not the legal owner of the asset. So if we're talking about real estate, for example, Ward Keever himself does not own the real estate. The Ward Keever Trust is the owner of the real estate. Well, why does that matter? That matters because when Ward passes away, only assets that he owned in his individual name will be subject to probate. So if the Ward Keever Trust owns the real estate, then that asset, the real estate, will not pass through the probate process. So we've defeated this year-long process, which is kind of cumbersome. And the benefit, of course, being in Delaware, we're avoiding this 2% probate fee, and we're avoiding the public nature of the probate process. A trust has two parts to it. The first part basically stipulates, while Ward, I've never said your name this many times, like ever. So the trust says, while Ward Keever is alive, the assets exist for his sole benefit. So while he's alive, he does with them what he wants. He can sell real estate, he can buy real estate, he can empty bank accounts, open bank accounts. They're completely his. The only difference is he will conduct business as Ward Keever trustee. Literally, he's just going to add that one word behind his name when he signs the check. The second part of the trust, it's helpful to think of, it really functions like a will. So we all think of wills as the documents that we have that say, when I pass away, I want my assets to go equally to my 3 kids. The second half of a trust, it really does function like a will. So part 1 of Ward's trust says, while I'm alive, the assets are mine. I do with them what I want. Part 2 says, when I pass away, I want my next in line trustee, who conceptually is like an executor, but it's a trustee. Ward's instructing my next in line trustee to distribute all of the trust assets equally to my 3 kids. So the difference is, the trustee reads the trust and says, okay, Ward has passed away. What am I supposed to do with these assets? Oh, I see that Ward wants me to distribute them equally to his 3 kids. You only have 2, to his 2 kids. So trustee is going to distribute the assets to Chip and Dan, and that happens very quickly. And the reason it happens very quickly is there is no court supervised process. So the trustee literally will just sign a deed transferring the real estate to Chip and Dan. He doesn't have to get court permission. It is a completely private process. And importantly, there is no 2% fee. So when I do trust administrations, the beneficiaries get their assets within a matter of months versus having to wait a whole year. So it's faster, private, and less expensive.
Yep. Before you move off the trust, I guess a couple of things that I would highlight there. When you own property, specifically real estate, outside of your primary state of residence, can you speak to what would happen if you didn't have a trust and why you might want to use a trust in that specific instance?
Yes. So a lot of my clients, probably a handful of people on this call, own real estate in different jurisdictions. So Florida and New Jersey, a lot of people have like shore houses and second homes, which is great. The problem is, if you pass away owning real estate in a different state, your executor is going to have to probate your estate in Florida or New Jersey. And we call that ancillary probate. So my in-laws, for example, have a second home in Hilton Head, South Carolina. They own it together, joint with right of survivorship. So they're okay right now because they're both alive. And when one of them passes away, the other will become the sole owner of the property, no probate, no problem. The problem is, though, when the second, so if my father-in-law passed away first and my mother-in-law owned the property, the problem is when she passes away, her son is going to have to open an estate for her in South Carolina for the sole purpose of dealing with this real estate, because she is a resident of Pennsylvania. So my advice to my in-laws and to all of my clients who have real estate in different jurisdictions is either set up trusts now and transfer title to your trusts now, even though you're both still alive, we can still transfer the real estate in. Or if you want to wait a little bit, make sure that when one of you has passed away, make sure the surviving spouse comes back and says, okay, Carolina, now I am the sole owner of this asset. I want to make sure that it avoids probate when I pass away. And at that point in time, we can transfer title into the trust to avoid ancillary probate when that person passes away. So I have some clients who say, you know what, as long as we're both alive, we're okay. We'll just take the wait and see approach. We'll wait to see which one of us passes away first. Then we'll do the trust planning. And I have some clients who say, let's just do all of the trust planning now. And I see this particularly with my older clients, because they say just the burden of having to coordinate all of this while I'm grieving, and I've just lost my spouse, it's just going to be too much and I'm not going to think of it, so let's just do it now. And they're both viable. It's just viable options. It's just important that it gets done.
Is there any disadvantage to doing it now while both spouses are alive? So
No.
That would be our recommendation typically for clients. General rule of thumb, if you have any property that you own outside of your primary state of residence, as part of your estate plan, get a revocable living trust established and retitle that asset into the revocable living trust. You still own it. Well, technically you don't, but you still control it, right, in the same way. But now, because it's owned by the trust, the surviving spouse does not have to go open up ancillary probate in that non-resident state, which can be a real hassle. One other thing I'd like to just point out on the topic of trusts is, when you have a will, basically, unless you create a trust within your will, and that's a different topic. So here today, we're talking about a separate revocable living trust document. Within a basic will, you just leave everything outright to your heirs. There may be reasons, in fact, we see more often than not, where you might want to sprinkle the money out to your heirs. So for example, if you had a $2 million net worth and you've got 2 kids and you pass away and each of the kids just gets $1 million dropped in their lap, that might not be helpful, right? The idea is that we want to be a blessing to our kids in terms of leaving them with resources and that sort of thing. And dropping $1 million on to somebody who's not prepared for that could be problematic. So could you speak for just a moment, Carolina, about how we might be able to use a trust to kind of sprinkle or spread out or over time distribute money out to the heirs?
So going back to, I don't know, 10, 15 minutes ago, when we were talking about beneficiary assets, so life insurance and retirement, and I'm going to tie all of this in together. One of the benefits of a trust is you can, what we estate planning attorneys like to say, we can control from the grave. So as Ward says, sometimes it's perfectly appropriate if you have, grown adult children. There's no reason not to leave them a sum of money outright. They take their money and it's theirs. But particularly for people who have younger kids, special needs kids, I see this a lot, or kids, unfortunately, who are in bad marriages. There is a concern of leaving money outright to them. So one of the things that we can do with a trust is structure the payout terms. So we can get like very, very complicated. We can keep it simple, but we can virtually do anything with trusts. So we can control the distribution of the assets up to a certain point. If we have a special needs beneficiary who is receiving a government benefit that requires that person not to have a big sum of money, there are planning techniques that we can implement where the money is available to that beneficiary without jeopardizing his government benefits. And sometimes the assets that people are mostly concerned about are life insurance policies, because the payouts are sometimes pretty significant. And they'll say to me, well, Carolina, I don't want my kids to have, you know, $300,000 each when I pass away. And if I name them as beneficiaries on the plan, then when I die, they're going to get that money. What can we do about it? Because they know, of course, that they cannot leave the beneficiary designation blank, because then it will default to the estate. So what I do a lot is I'll set up a revocable living trust, and I will name the trust as the beneficiary of the life insurance policy. So rather than name Bob and Sally, my children in their 20s, as beneficiaries of the life insurance policy, I'm going to name the trust as the beneficiary. So when I pass away, the money's going to dump into the trust, and from the trust, I'm going to control where the money goes, because I'm going to tell the trustee, don't give Bob and Sally their money right away. I want you to hold it until they're each 35 or 40. You can use it at your discretion for college tuition or a down payment on our house or medical expenses, but you, trustee, are going to control the money until they reach this age. And what that does is it obviously protects the money from them, because, you know, kids can be impulsive and spend money frivolously. The other important thing that it accomplishes, though, Ward likes to use this phrase that I have adopted, of creditors and predators. So if you leave money directly to Bob and Sally and they have creditors, or they're in bad marriages, their money, your money that you have left to them, is going to get taken by the creditors, or it's going to be subject to a marital dissolution order. If, however, you leave the money in a trust, the creditors and predators can't get to it, because technically it is still your money. So it's your money as long as it's in trust. As soon as it leaves the trust, it's not your money anymore. So we can really control how money is distributed. I can also set up these revocable living trusts so that they are the beneficiaries of retirement assets. And I will not get into this, because then this, as Ward knows, this is going to get very, very complicated. But for our purposes, it's enough to understand we can direct these assets into the trust so that they will ultimately make it to your intended beneficiaries, but we can control it a little bit. Okay?
Perfect.
All right. So I'm going to just...
You could talk about life insurance if you want.
Yeah, I just wanted to see. Okay. So life insurance is a really great asset to have if you don't have it already. One of the reasons that I really like life insurance policies is because it is a great way, as I said before, it's a great way to get money to beneficiaries quickly. So I have a lot of clients who worry, well, when I pass away, I don't want to burden my kids with paying for my funeral or paying for my final expenses. I don't want them to have to go out of pocket for those expenses. What should I do? So a good thing to do is to name them as beneficiaries of these life insurance policies, if it's an appropriate context to do so, because the money pays out to them directly. They don't have to go into their own pockets to pay for these final expenses. Now, of course, if you do that, what we can't do is control it beyond the beneficiary designation. So if you have concerns about your beneficiaries receiving all of this money, then perhaps it is not a good idea to name them as beneficiary. But if you have concerns that they're not going to have enough money to pay for your funeral, then it is a good idea. So ultimately, this gets back to what I was saying before. It is just really important that you meet with professionals who understand what the stakes are. I think particularly when it comes to estate planning attorneys, there are really great estate planning attorneys who are technically very gifted drafters, But unless you have been through the estate administration, you don't know what pitfalls to look out for when you're drafting. So having the benefit of 10 years of probate work, I think I've been through enough, surprises on the administration side to know what to look out for when we're doing the planning. It is also possible to buy life insurance and have a different kind of trust own it. But I think, Ward, probably we don't need to get into ILITs right now. Do you think?
I would concur.
Okay. Anything else you want me to mention, you think I should mention about life insurance?
I would just add, I think life insurance, certainly it provides liquidity to cover final expenses, and that's helpful. It can also provide liquidity to cover different types of taxes, whether, if your probate wasn't set up correctly and we're having to pay probate fees. If you wanted to, for example, keep a family vacation home in the family and make sure there was sufficient money available to cover property taxes and maintenance and upkeep. If you owned a business and maybe one of your kids was active in the business and you didn't want that adult child to wind up in partnership with the inactive children, you can use life insurance to do what's called estate equalization or estate balancing. So I've never encountered a beneficiary who said to me, we have plenty of money, I don't need all this life insurance, send it back, right?
Right.
But unfortunately, we have certainly encountered many circumstances where there was insufficient liquidity, insufficient cash. So life insurance can serve a variety of different purposes, regardless of the age at which somebody passes away.
One thing I wanted to mention, because you talked about business ownership, and I had intended to say something about this, so I'm glad you reminded me. It is not uncommon for people to own business interests. A lot of my clients are members of LLCs, whether they're single member LLCs or multiple member LLCs, or they own, they have shares in some kind of corporation. It is very, very, very important to consider those interests when you're doing an estate plan. And the reason I say that is, if you own an interest in an LLC and you pass away owning 50% of the LLC, that 50% interest is going to pass through probate. And in order for it to pass through probate, it has to be assessed this 2% fee. And the Register of Wills is going to require that the business as a whole be valued so it can determine what the 2% is. So I actually see this quite a bit, and this gets to Ward's point that he made earlier. It's one thing to set up your estate plan and sign the documents. It's another thing altogether to make sure that your assets are pointing in the right direction or are actually transferred into the trust. So when I have clients who tell me that they own business interests, I almost always advise them, set up a trust, move the business interest into the trust. It is surprisingly easy to do. So if you own, if you're a member of an LLC, all we have to do is sign a piece of paper. I shouldn't say all, I'm simplifying the process, but it is fairly straightforward. You sign a piece of paper that says, I am transferring my 50% ownership of the LLC into my trust. And what does that accomplish? When you pass away, because the interest is owned by the trust, it doesn't have to go through probate. If we're talking about shares in a corporation, we have to issue new shares of the stock. So it is fairly straightforward, and we do it quite a bit. But I find it to be heartbreaking when I help somebody administer a trust. So the person has passed away, and I'm so excited because this person had a trust, so we don't have to go through probate, except this person, while he was alive, he didn't do anything about his business interest, and now we have to open a full estate for the sole purpose of dealing with this business interest. So it's just important to make sure you have everything accounted for.
What I hear you saying is that the probate fee is a voluntary fee, and of course, fee is another word for tax.
Right.
So the probate fee or the probate tax is completely voluntary. You do not have to pay the probate fee, aka the probate tax. The key is that you have to plan in advance. Because if you don't plan in advance, once you pass away, it's no longer optional. So the importance of avoiding that.
Yes, absolutely. And I will also mention, going full circle back to the beginning of this conversation, if you decide right now, you know what, we're not ready to do all of this estate planning, which I understand because it's a lot to take in. And if it's done the right way, and Ward, you can attest to this, if it's done the right way, it should take a while, not 6 months, but to do it properly, it's an investment of your time, right? Ward, would you agree with that?
I agree.
So it does take some time to do it the right way. If you're not ready to do trust planning, for example, right now, that's okay. At a minimum, make sure you have a power of attorney in place, because in that power of attorney, you can authorize your spouse or your children or your next door neighbor or whomever, you can authorize that person to do the trust planning for you. So somebody other than you needs to have the authority to do this. So at a minimum, everybody should have a power of attorney. If there is no power of attorney in place and something happens, there's virtually nothing that we can do without me having to petition Chancery Court to ask for permission. And at that point, you're paying attorney's fees, the court is backed up, everything's going to take longer. So the piece of paper is just an easier way to go.
Great. And Carolina, I think I would point out also that you say that when things go through probate, it typically takes about a year, maybe 10 or 11 months, maybe 14 or 15 months, but that's if nobody contests.
Yes.
Right?
Yes.
So do you want to just speak to that for a moment, and maybe also how that compares and contrasts to a trust? Do people generally contest a trust? How does that work?
So I get asked quite a bit, what can I do to guarantee that no one's going to contest this document? And the answer is nothing. I can't guarantee that your daughter isn't going to complain about how she was treated in the distribution of your assets. But what we can do is put some provisions in to disincentivize people from contesting. But Ward, your question is, well, what happens if there's a will contest? If the will contest is happening, if the contest is happening as part of the probate process, then the resolution takes longer because there is a judicial body involved. The Register of Wills has to be kept apprised of what's happened. There's a process, I will say. So it by necessity takes a little bit longer. There can be a dispute in a trust, and this happens sometimes. But my experience has been that the resolution of a contest in a trust, sometimes it doesn't usually take as long, because remember, there really isn't this judicial oversight, which is not to say that the court doesn't get involved. So if there's a beneficiary who is really, 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 really unhappy, he can force the court to get involved, but they usually don't. So trust disputes are typically handled more quietly, and they tend to be resolved more quickly. Again, this is a generalization, but the point that you're prompting me to make, and I agree with, is trusts in general are easier to deal with. They take a little bit more work on the front end to set up, that's true, but what you are doing is really saving a lot of time and expense for your loved ones who are going to be left to administer the trust. And I would say 95% of my clients come to me and they say, Carolina, our primary objective is we want to treat our kids equally. And Ward, I'm sure your clients say the same thing. Our objectives are, we want to be equitable with our children, and we want to make this process as simple for them as possible, right? That's what your clients would also say. And the way to do that is with trust planning.
I think it's important to understand that if you just have a basic will, it could take, a year to go through probate, but if that will is contested, now it could take several years. And that's...
Yeah, I'm still dealing with a will with an estate that was opened in 2016. So, yes.
Because somebody contested, somebody disagreed, whatever else. Yeah, and it's all public. It's all public record because it's a will. It's a public document. So, yep. Well, Carolina, we are getting to the top of the hour, so I realize that I, as usual, asked you questions and took you on rabbit trails and segues and all kinds of different things. Are there any closing things that you want to cover that we did not touch on?
No, I don't think so. I have seen a lot, like the last year, 14 months, my opinion has always been that everybody needs an estate plan, but my perspective has really changed over the last 14 months because I have seen a lot of what happens when people don't have estate plans in place. And again, not everybody needs to have a trust right now, but I just really urge everybody, and I'm not saying you have to come see me to do it, but just go see an attorney and at a minimum, have a power of attorney in place and have a healthcare power of attorney in place. If you have kids who are at least age 18, they also need to have the documents in place because as sad as it is, you do not have a right to their information or make decisions for them anymore. So, it's just important, and it really should not take a long time. Those documents do not take long, so just get those done at a minimum.
Yep, very inexpensive, easy to get done. I would say, when both of our boys turned 18, we immediately had them go get the power of attorney and the healthcare directive. I'm familiar with a situation where folks had their son went off to college and was away on a weekend skiing with friends and wound up hospitalized in a coma. And it just was a really bad scene because, again, there was no documents, there's no healthcare directives, there's nothing else. The parents show up at the hospital, the doctors won't release information to them because the 19-year-old is an adult. So it's a couple of $100, if that, to get a power of attorney, healthcare directive for your 18-year-old or 19-year-old kid, definitely before they go off to college. Yeah. I would wrap up just by saying, there's a saying that I think is really true. You never really know someone until you share an inheritance with them, right? So everyone is going to leave a legacy. What do you want your legacy to be? You could leave an absolute mess with your affairs in complete disarray, or you can take a little bit of time and energy and a little bit of money, visit with Carolina, work with your financial advisor to get your estate plan in place so that the legacy that you leave is exactly what you want, and you leave order and influence. Tell you what, it's a great opportunity to transmit your values to your heirs while you're transmitting money to your heirs. So, we don't necessarily talk about, quote, rule from the grave, but we do talk about money approximately equals influence. And so the ability to convey your wealth along with your values, an estate plan is a great way to be able to do that. So, Carolina, we thank you so much for your time today. And I'm glad that we didn't get into any other stories, per se. We'll leave those for another time.
Yeah. So, thank you, Ward. As always, this was wonderful. Michelle, thank you for your technical expertise.
And so if our clients would like to reach you, do you have a slide with your contact information, or can you provide us with
I hope I do, Ward. We're going to find out.
There's our contact information.
There's yours.
You can contact us, go in touch with Carolina.
There you go.
You're going to contact Michelle, and then you'll contact me.
And just to clarify that very frequently, our clients who are utilizing Carolina's services will, you can either meet Carolina in her office in Hockessin, or with some frequency, Carolina will actually come here to our Stone Barn offices as a convenience to our clients. So we've worked very, very well together. We are big fans of Carolina for many reasons. She does a great job for our clients, and so we're happy to have her on our conversation today. So with that, folks, this concludes the most recent installment of our Stone Barn Speaker Series. And again, we're honored to have Carolina Heinle, estate planning attorney from Hockessin, Delaware, licensed in both Delaware and Pennsylvania. If you have questions, please give a call to our office or send us an email, and we'd be happy to put you in touch with Carolina.